The European Data Directive basically prohibits transfer of a European resident's data to a place that treats this information in a lesser way than the Europeans see it, and that means to the US. So there's a safe harbor in place, there are mechanisms around that, but you just need to be aware that this is not just an interesting conversation. You need to start thinking about what you have and how you keep it. So that's generally data. What do you do with this stuff? I suggest that you understand a data flow. Do we have any technologists in the room? Any IT folks? Okay, this is Northeastern. I am not a technologist, although I'm learning more and more about it as I continue in this field. But a data flow is basically where the information comes into your system, specifically on your servers. Where does it come? Where does it live? And who has access to that? And ultimately, where does it wind up and how do you get rid of it? So if you have a chart of how this information gets onto your network and where it stays in there, it will help you in a whole host of matters. So you want to try and begin to understand this. If you don't have, if you're in-house, and you have a technology department somewhere, and those are all the engineers and tech folks, and you understand what they talk about. You want to start developing a relationship and being able to communicate clearly with them and understand what they do so that they can help protect your organization. So you're going to have some sort of data flow, understand how it comes in, even if it's entered manually. If you have a job applicant and they fill out an application, you ultimately are going to put that stuff somewhere on your server. Somebody's going to put in the person's name, address, social security number, etc. Understand where it comes in and how it goes through your system. Where it's kept, is it backed up on the same server as all of your other information? The security for online stuff, a lot of it will also apply in the physical world, so that physical application that somebody fills out, if people still fill those out, lots of things are also done online, so that's another way to make sure you understand where it comes in, where it's adjusted. But you take precautions generally, I'd like to think, of those physical applications that are kept in a file drawer, that it's not kept out in the middle of the kitchen or the coffee area, and it's supposedly secure. You need to track it the same way online, know where it is. Who has access? Generally, again, if you're thinking of a physical application or information about an employee, you don't keep that in a place where an intern can necessarily access it, right? It needs to be the same with your online data. It needs to be kept in a place that not everybody in the company has access to it. As a general rule of thumb, only people who need to know the information and need to know it for their job function should be able to access it. So that means you should keep it separate from all of the other stuff on your network and on your server. So you need to know what's happening on your system, because that's going to help you to identify unauthorized use, which will lead you to breach notification. When your system is breached, you need to notify. Who you notify, when you notify, about what and how, all depends on each state. There are 46 states with data breach notification laws. They're all a little bit different. The only federal uniform data breach notification law has to do with HIPAA, which I will very briefly define as best I can. And with HIPAA, if you have a breach where 500 individuals' information has somehow been compromised, you need to notify by notifying the media as well as HHS, okay, in addition to the individual. There are some states where you have to notify the Attorney General. There are some states where you also need to notify the local police authority, if that's the police department or the sheriff's office. When you notify, it can be anywhere from 60 to 90 days, 45 days, as soon as you know about the breach. It all depends. So you need to understand when your information has been potentially compromised, what has been compromised, how long this has been happening, who is impacted, and have some sort of a plan in place, even if that's just calling outside counsel who's going to help you put together a plan to notify who you need to. There are fines, both criminal and civil. So it's not something to take lightly, which is why what data you have, where you have it, and understanding how this all works from a tech perspective is really important to make sure that you are protected. Somebody else is going to touch upon this as well, I believe, but this also leads to bring your own device. People have tablets, smartphones, laptops that they like to use, and use them in the work context. And it's becoming more and more popular and acceptable in different organizations to do that. There's a whole myriad of issues that comes up when people bring their own devices. For one thing, your IT department is going to have to manage various devices on various platforms, sometimes conflicting. There are malware issues and viruses that can be brought into your environment. There's, of course, the security of the device. If somebody has access or has information on their smartphone and they leave it somewhere, or it's lost or it's stolen, is that device secure? Is that information that's on that device going to be compromised? Theft, loss are big deals, loss mostly. One thing to consider is, where does the information reside? Is it on the actual device? Is it just being able to remote in to your environment? All things to think about. The other, I think, very interesting thing about this is the mix of your personal and your business. So if I'm using my smartphone for work, but I also have my personal contact information there, and something happens, what happens if that device needs to be either used in a discovery situation? People are going to have access to all of my personal stuff, or if it needs to be wiped out. And having the ability to wipe out a device so that all of the stuff there is not accessible by anyone else is part of the safety measures you should consider and have in place. So that means that somebody's picture of their 2-year-old, is going to be wiped out. Does the employee understand this? Should they have a separate device? Should it all be used? These are things you need to think about and establish your own policies and procedures. It's something you may, depending on your organization, want to take a poll or survey, see how your employees feel about it. You don't want anybody using their own device. I think it's hard to really prevent that. Even a laptop that's sitting in somebody's home that they remote in, that's a device. You don't know what lives on there, separate and apart from your business stuff. So have a policy. Think about it. Think about what's going to work for you and your own organization.
Not going to word data, I promise. I'm going to be talking a little bit about social networking in mostly the non-union setting, and what the NLRA, how it's being interpreted right now by the judges and the board, and what kinds of communications are protected, what kinds of rules are protected and not protected, etc. The good news is there's not much law yet. The flip side of that is we're using the old law and we're giving it a new twist. We're not reinventing anything to accommodate the new media of Facebook, etc. We are trying to apply laws in the concerted protected activity arena to communications and activity on Facebook, etc. I'm going to just say Facebook for now. Okay, for the rest of the time, I'm just going to say Facebook, but that's what we call them. We call them the Facebook cases. So far, there are almost none. I will talk about 2 of them. I want to start with one, actually. I want to tell you, give you a brief scenario of the kinds of things that are happening in a non-unionized workplace. In a unionized workplace, usually the parties figure this out and either included in their collective bargaining agreements or in some sort of memorandum of understanding what kinds of activities will and won't be tolerated. But in the non-union setting, most employers think that they don't have to deal with this, and they very much do. Here's the situation. An employee came to work for a social service agency out in Buffalo and quickly began to run around complaining about the performance of all her coworkers, saying that they were lazy, they didn't do anything, they weren't taking good care of their clients, etc. Well, you can imagine that kind of annoyed them. And one of them had had enough of this, and so she went on Facebook, because that's the first thing everybody does, is go on Facebook, and she said to whoever was out there listening, I am so sick of this woman just, bad-mouthing us and saying that we're poor performers. Anybody else agree with me? And she literally had that question, how does anyone else feel? And naturally, a bunch of her coworkers began to respond in not so delicate ways. They said things like, what the fuck? Try doing my job. I have 5 programs. What the hell? We don't have a life as it is. What else can we do? Tell her to come do my fucking job and see if I don't do enough. This is just dumb, et cetera, et cetera, et cetera. This is the dialogue that went on Facebook. The 5 employees, well, 5 of the 6 employees, but the 5 who really engaged in this kind of dialogue via Facebook were all fired. And it is undisputed that they were fired for this communication. So the question is it protected activity? Is it covered by the National Labor Relations Act? Is it concerted activity? And there's no dispute that employees were actually fired for this. So that's not a factual issue that we had to deal with at all. And did it somehow lose the protection of the act because of the coarseness of the dialogue, or because it in some way harassed or threatened this individual who was going around disparaging her coworkers? Here's the simple analysis, and now I'm going to get into a little bit of detail. It is very much concerted activity. There is an employee who reaches out to other employees. Doesn't matter what the forum is. It doesn't matter if they're sitting around the lunchroom table. It doesn't matter if they're hanging out in the parking lot having a cigarette, or if they're doing it from the privacy of their own homes on Facebook. And by the way, they were all doing it from the privacy of their own homes or someplace, not the employer's computers and not the employer's space, physical space. And they started to share their concerns about this person and the things that she was saying about them, and whether or not, one of them in particular heard directly from the employee who was disparaging them, that she was thinking about going to management with those concerns. Well, that kind of ramped up employees' concerns, and whether it was true or not, they were having this discussion. It is very much concerted. It is a conversation among employees about their employment, some term or condition of their employment. Is it protected? It absolutely is, because it deals with terms and conditions of employment, and only because of that. If they were talking about this individual, I don't know, dating this manager's brother-in-law or sleeping with one of the supervisors or something like that, has nothing to do with terms and conditions of employment. It would not be protected activity. Again, I'll get into that in a little bit more detail. But I want to start with this illustration. So the employer said, well, wait a minute. It may have been protected and concerted, but the communications lost their protection because of the content and the tone of the communications. In particular, the employer said, they were harassing this woman. Well, there's nothing, this is where the facts matter, there's nothing in the communication that harasses her. They are reacting to what she said about them, but there is nothing here directed at her. There's no threats, there's nothing that can be construed as harassment. And so the board, not the board, the administrative law judge found that the conduct never lost its protection. The fact that there's vulgarity in it is really irrelevant. It's not threatening. It doesn't interfere with the discipline of the workplace. Those are the kinds of phrases that you're going to hear in this context. Not, was it mean, and not, was it vulgar. In this setting where employees are having a discussion among themselves about their terms and conditions of employment, this is the easy case. That's why I wanted to start here. This is a very, very easy case. I imagine that's why it didn't get appealed. The board is never going to deal with this case. This is an administrative law judge's decision.
And I start to open my mouth and I look in the front row is Rosemary Pye, who, as you've just learned, is the former regional director of the NLRB. And so I took a slightly different tack at that talk. But the NLRB is out of its mind. And it is affecting nowadays non-union employers to a much greater extent than it ever has. And these cases really are a great demonstration. I think that one of the things for those of us who have represented employers for a long time, one of the things that really has surprised us is that a lot of what's coming out of the NLRB is counterintuitive to the things we've been telling clients for quite a long time. I mean, I have the employment at will mantra down to the point that I can be on the phone saying a good reason, a bad reason, no reason whatsoever, and here's what that really means, and not even actually be awake. And I'm telling the employer about how, yeah, and if they come in a red tie and you've decided that you don't like a red tie, you can fire them for that, it's a bad reason, but we don't care because you're allowed to do it. And one of the things that always was on that list was insubordination. I mean, if you are actively out there saying horrible things about your employer to the entire world, it was one of those things that we always said to people, that's okay. You can fire this person. They're out there saying horrible things about you. And now we're not so sure. Now, so the case that I thought was an actual easier case from the NLRB was, the first one deals with ambulance providers. And it was a case where the employee there was a customer complaint about this employee. And so she gets asked to write up an incident report, and she says, I want to exercise my Weingarten rights. I want a representative present while I write this up. And the employer says, no, we don't think so. And she goes on Facebook and talking about her supervisor, first says, it's nice to see that they've hired a 17, which apparently is slang for a mental patient. She refers to her supervisor as a dick and a scumbag, and she is then suspended and fired for violating the company's social media policies. Now, the policy prohibited making disparaging comments about the company, employees, and supervisors, and it prohibited depicting the company in the media, including the internet, without the company's permission. And that's sort of important because when you talk about depicting the company, what they're really talking about is, we don't want you using our logo on your site, on your blog, on your Twitter, on Facebook. And the NLRB came back and said, nope, we think that this termination was unlawful. The case ended up settling. But the first part I get. I really do get the first part, because there was this action where the person is exercising these Weingarten rights. Whether or not she was really entitled to a union rep doesn't really matter. It's clear that they were retaliating against her, and she made a complaint about that. That part I get. The part that I didn't quite get is that the NLRB went further and said, well, first of all, we don't like this ban on disparaging statements. And their concern was, well, what is a disparaging statement? A disparaging statement might include things like, we don't like the conditions of employment. Okay. And so they said what you really need is a carve-out. And this is sort of an important takeaway for employers. You need a carve-out that basically says, what we are not saying that you can't complain about terms and conditions of your employment. I'd recommend that you not simply say, we don't mean your Section 7 rights, because the NLRB has said, appropriately, no one knows what you're talking about if you say that in your carve-out. You need to actually tell people what you're talking about. The blanket ban on the use of the company's logo, I thought was interesting, because the NLRB, you think that companies have a right to control their intellectual property, but what the NLRB came back and said was, well, if you read that to mean what it says, that might mean that you can't take pictures of people picketing outside of the place of employment, and we don't like that because it doesn't have the carve-out. So, okay, that one was, I think, one of the simpler cases. The Hispanics United of Buffalo case, which Beth started to talk about, it starts to get more interesting, because the employee who was being complained about, and this is, again, the case where there was one employee who was recently hired who starts saying, complaining about her fellow employees. And so they take to Facebook and have a grand old time talking about how she doesn't know what she's talking about and she needs to try doing their jobs. And the thing that concerns me as someone who represents employers, and I think the thing that concerned the employer, was all of a sudden things are starting to bump up against what does feel like a harassment policy. There are at least 5 employees who are all posting about this supervisor, and it comes to the attention of the executive director, and those employees are terminated. Now, the ALJ, in writing the decision, said it's irrelevant to this case that the discriminees were not trying to change their working conditions, and that they did not communicate their concerns to the respondent. And so it starts to get, for employers, more and more confusing, because you've got things that are bumping up against each other, concerns that are bumping up against each other. We have a harassment policy. You're not supposed to harass fellow employees. Well, what happens if the NLRB says it's not harassing, it's really simply expressing concern? The hot dog case. Now, I appreciate the fact that the NLRB came out and said, you know what, we actually think that the termination wasn't over the hot dog postings. We think the termination was legitimately over the postings about the Land Rover driving over the client's foot and into a lake. And quite honestly, the NLRB says, quite honestly, we could see where the employer is a little concerned about that. It's a safety issue, fun of a safety issue. So that's okay. But when Beth says that the employee was sarcastic, it is a bit of an understatement. Here's what he said about the rollout of the BMW Series 5. I was happy to see that now it's the employer went, quote, all out for the most important launch of a BMW in years, the new 5 Series. A car that will generate tens and millions of dollars in revenues for Counts over the next few years. The small 8-ounce bag of chips and the $2 cookie plate from Sam's Club and the semi-fresh apples and oranges were such a nice touch. But to top it off, the hot dog cart, where our clients could obtain an overcooked wiener and a stale bun. I mean, this is what he's posting on Facebook for the world. And that's the part that I think the NLRB is out of its mind, because there has traditionally been an idea that you cannot broadcast through a megaphone complaints about an employer in this fashion. And the idea that the NLRB came back and said that this had to do with terms and conditions of employment, quite honestly from the other side, seemed to be a bit of a stretch. The rationale from the NLRB was essentially the employees worked on commission. The commissions could be theoretically affected by how many people are impressed by the rollout of the Series 5. Therefore, when you complain about how shabbily your employer is treating the customers with the stale hot dog buns, you are engaged in concerted activity for terms and conditions of your workplace. And quite honestly, none of the employers that I represent understand that at all. The idea that you can go on the internet and simply mock and ridicule the employer, and that is going to be found to be concerted activities, is concerning to a lot of employers. Here is some language that the NLRB would not approve of. Never post inaccurate information about the company or its officers, employees, shareholders, customers, suppliers, partners, or competitors. The NLRB does not like this language because it says that when you prohibit people or require people to be completely accurate and not misleading, it could be reasonably interpreted to apply to discussions about or criticism of the labor and employment policies. Now, I understand the idea that you don't want to interfere with an employee's Section 7 rights, but the general rule of saying, when you post something on the internet, make sure it's true, that would be found to be overbroad from the employer's perspective is a little crazy. Avoid sharing your personal information and other people's personal information beyond what is absolutely necessary. That's a really tough one for employers, because from the employer's perspective, you can see the rationale behind it. There are people who post lots of things on Facebook, and there are people who are more private. And the idea that one employee may go out there and post online what another employee might consider to be private information is concerning to an employer, and you know, most of us would think that when we write the policies that it's an appropriate thing to include. The NLRB found it to be unlawful, and again said, well, you could be talking about the terms and conditions of employment because you could be talking about things like salaries. And so it's an interesting area where the concerns of the two different competing sides really do clash.
Thank you. So I hadn't planned on talking too much about the social media case that's coming out of the NLRB, but having heard two panelists, and particularly Evan's comments, I want to add a few thoughts about that from my perspective, which is as a practitioner on the labor union side and on the side of individual employees. So the NLRB may or may not be out of its mind, but if it's been out of its mind, it's been out of its mind since the 1930s. The law that's being applied in the social media context is not new. This is directly from the statute enacted in 1935, and the very principles and policies that are being applied in the social media context are really, really old. These are from cases going back not just to earlier this decade, but to the 40s and 50s and 60s. The idea that the NLRA applies to employees in the non-union workplace, also not a novel concept, at least legally. And indeed, Supreme Court precedent from the 1960s establishes that point with crystal clarity. So the fact that there are an abundance of employers who have been caught unaware through the most recent media attention surrounding the social media cases is really more of a testament to the lack of prosecution of cases at the NLRB on behalf of employees in the non-union workforce, rather than any change whatsoever of any kind at the NLRB. All of these rules are really, really old, long-standing, and in some ways is newfangled as the social media cases appear to be from media reports. In fact, I think that of all of the social media cases that have been either prosecuted or threatened to be prosecuted by the general counsel, decided by a judge, or I think there may be only one case that's ever reached the actual 5-member NLRB in Washington. If you were to assemble a panel of labor practitioners, we could have predicted with 98% precision the outcome of each one of those cases. That the outcomes of these cases are not surprising. That doesn't mean it's not outrageous, and that's an opinion, and you can hold that opinion. But I don't think that the outcomes are in any way surprising. So talking about the, I don't know, I'll go through each one of the cases, but the BMW case, the hot dog case, where the salesman complained about about the companies serving hot dogs at a luxury car event and how that's going to hurt their commissions. I find it hard to believe that that case could have come out differently on that point. There was an employee, sarcastic to be sure, although I hadn't read that case in a while, and the way you prefaced the statements, I was really bracing for something juicy, and I actually found that comment fairly tame. Barely rising to the level of interesting. Never mind. No profanity. There were no profanities in that comment. That's what employees do when they are complaining about activity at their workplace. It's about their working conditions. They talk to their coworkers about it. It's an emotional topic. It's something that people care quite a bit about. And it's something, obviously, that employers care a lot about, too. If employees are going to have the space and breathing room to bring social change to their workplace, they need this incredibly large space in order to make that change happen. Because if they don't have that space, the clear imbalance of power between employees and employers don't have the ability to generate leverage, generate momentum in order to get together and to make those changes in the workplace. Now, in terms of the policies, the sort of the broader handbook type cases that come up where there may not necessarily have been any employee discipline, but nonetheless someone's complained about the policy, the claim being that the policy either bans employees from engaging in Section 7 activity or somehow chills employees in the exercise of that activity. Those cases, too, I think, were highly predictable before they were brought to the attention of the NLRB. There tend to be more of those cases because unions that are engaging in organizing campaigns will be more likely to bring those handbooks to the attention of the NLRB or also a state labor relations agency in the public sector. There are cases are few and far between where individual employees in a non-union setting or a non-organizing setting bring charges before labor relations agencies. Those cases are very predictable. I would also add, I don't think they're particularly controversial or they shouldn't be. So clearly in all of those cases, there was some employer somewhere who itself was caught off guard and potentially their labor and employment attorney was left red-faced at the end of it because they didn't identify an issue that clearly caused a problem for the company. But it is remarkably easy to include a carve-out in these handbook policies for Section 7 activity. So looking at some of the just some of the examples that were raised. You know, the when in doubt, ask before you act. You know, check with your HR manager to see if it's okay to complain about. You know, it's not exactly. So. All the employer there has to do is to carve out the NLRA-related activity. And it can continue, if it does that, having that broader rule is okay. You know, a rule about never posting inaccurate information, that's okay, so long as you carve out information about employees' working conditions so that employees aren't unreasonably chill in discussing their working conditions publicly. You know, the idea about asking yourself whether it's appropriate to friend someone on Facebook or some social media site, same idea. Carve out the Section 7 activity, not a problem. Don't disseminate confidential information, which by the way includes your wages. Carve out the wages if you don't want people disseminating your trade secrets. It may be that people have been caught unaware of that, but there is a recipe, and apparently it's in this handout, of how to go about drafting handbook policies lawfully. So I add that to the conversation that, and this is probably why I wasn't in charge of the marketing for the panel, that there's nothing new here. This is all, there's a shimmer of newness because of the media attention, but nothing new happening at all. Our claims about invasion of privacy, I as a practitioner get a lot of questions from clients, most of whom I turn away for reasons that we'll talk about, whose employer has either fired them, disciplined them, or criticized them because of something they've done on Facebook. Now, if the case was about wages, hours, and working conditions, and it was concerted, obviously that's a special case that you've already heard about. But more often than that, I think people are just finding that they feel that their private life has been invaded by an employer who's nosy and had no business looking into that employee's private life. Very briefly, I want to talk mostly about a non-union setting, but to talk about a unionized setting, two important points that I think most people in this room will grasp intuitively. If you're in a unionized setting, disciplinary policies are a mandatory subject of bargaining, meaning that both sides have to bargain about it, and most likely there's going to be something in the collective bargaining agreement that addresses it. It may be nothing more specific than the employer, can only fire employees for just cause, but nonetheless, that is a serious restriction on the employer's conduct and will apply in these types of cases as